All right. State of Florida, but young, very talented, Mandela, judge, all persons that have been before the court, draw near, give attention, and you will be heard. The God save the United States of America, state of Florida, this honorable court. Please be seated.
Good afternoon. My name is Judge Mary Nardella. I'm joined on the panel today. To my left is Judge Brian Lambert. He has been on temporary assignment with our court. And when I say temporary, for a year from our Chief Justice. And we are very grateful for his guidance and help. He helped create the 60 CA when we were first formed and has been helping us for the last year. And we are very grateful. And to my right is Judge Joshua Mize. We have today two cases. They're obviously related, one a direct and one a derivative, 23-4292 and 23-4293. Appellant Michael Lipsey versus Scott Francis, derivatively on behalf of Parkway Properties Investment, LLC, and James Heisted. We are giving 30 minutes to each side, which is unusual. We typically give 20. We're going to give 30. For the appellant, we typically reserve 5 minutes for rebuttal, but if you'd like a different increment of time, please let us know. Counsel, how much time would you like for rebuttal?
I think 5 minutes will be fine. Honestly, I'll handle unless the court has a lot of questions. I wouldn't expect that I'll actually take all 30 minutes because so much of it for both appeals. This is
Understood. Well, counsel, whenever you're ready to proceed, we're being live streamed. I'll give you that. But whenever you're ready, come on up and you can start your argument.
Good afternoon. May it please the court. My name is Lauren Purdy. I'm with the law firm of Gunster, Yoakley and Stewart. With me at counsel table is my law partner, Nate Hill, and together we represent the appellant, Michael Jason Lipsey. The issue in this case is pretty straightforward, really, and there's a limited record and a limited set of facts before the court. And that is whether a Florida court can exercise personal jurisdiction over Mr. Lipsey, a Colorado resident, although Mr. Lipsey's only connection to the state of Florida is in his capacity as the former CEO of Parkway. All of the allegations directed to Mr. Lipsey relate to actions he allegedly took as the CEO of Parkway.
So I'm really interested in that. And in terms of the corporate shield doctrine, I didn't see a lot of cases applying it, actually tying it to the language of 48193. And I'm not sure why you would just invent it if you got a statute and it doesn't include something. I wouldn't expect it to be included. It's not like it's a constitutional requirement. You don't consider the constitutional requirements at the statutory level. You do that at the due process step. And so, you argue all this was in his corporate capacity. And I think most of the contacts they allege, your affidavit doesn't refute. You just say they were in his corporate capacity. And I think looking at the corporate shield doctrine and trying to see where it might be derived from the language of the statute. And if there is a case that made this connection and said, here's the language we're basing it on, please let me know. I didn't see it. But I think that under the language of the statute, the corporate shield doctrine makes a lot of sense for a specific jurisdiction, right? Because subsection 1 of 48193 says you have to do one of the acts in that section personally, right? And if you're doing them as a corporate actor, as an agent, you're not doing them personally. And so I could see really easily where you could derive the corporate shield doctrine from the language of subsection 1. Subsection 2 doesn't use the word personally. It just says a person is subject to jurisdiction if they engaged in substantial and not isolated activity within the state. Doesn't say it needs to be done personally. Doesn't give any language that would indicate to me it matters whether it was done in their corporate capacity. So can you tell me, based on the language of the long arm statute, at least for the general jurisdiction provision, A, do you agree with what I'm saying about the subsection 1? And for the general jurisdiction, is there some language in the statute from which we should find that there is a corporate? I know the other DC have said that, but is there some language in the statute that supports the idea that there's a corporate shield doctrine for subsection 2, general jurisdiction?
So Judge Mize, first, I do agree that with respect to the specific jurisdiction provision, it specifically speaks to acts taken in personally, that the the non-resident has taken personally. So that's a pretty clear, easy hook that would line up with the way that the corporate shield doctrine works. With respect to subsection 2 and the general jurisdiction statute, it says, as you know better than I do, a defendant who is engaged in substantial and not isolated activity within the state, whether or not such activity is wholly interstate, or otherwise, is subject to jurisdiction of the courts of this state, whether or not the claim arises from that activity. I would concede that there's not the same obvious textual hook in subsection 2 as there is with subsection 1. I have no problem conceding that. However, there are multiple reasons why applying general jurisdiction to an out-of-state individual sued in their individual capacity for actions taken solely in their corporate capacity would be inconsistent with long-standing Florida common law on the application of general jurisdiction.
Okay, that's fine. I'm interested in that, but I just want to know, I'm taking that as an answer that there's no textual basis in the statute. If there is, and I want to hear the other things, if there's others, but I do want to know this. Is there a textual basis in subsection 2? If there is, what is it? And if there's not, you can just say there's not, and here's the rest of my arguments, and I like to hear them.
I think I would have to concede, Judge Mize, that there is not the same clear textual argument.
Is there any textual argument? If there is, point me towards it. I'm not saying there is. I don't think there is, but I want to make sure I'm right. If there is, now's your chance to tell me. Is there any textual argument in subsection 2?
I don't think, to be honest, Judge Mize, that courts have really to this point even focused on that component of general jurisdiction in terms of what it textually provides in the long-arm statute. So nothing is coming to mind to be.
That makes sense, counsel. I'm sure you're aware of the Doe case from the Florida Supreme Court, and that was looking at subsection 1
Mhm.
and personally, correct, not subsection 2.
Correct. Yes. Now, what I will say, Judge Mize, is again, long-standing common law principles relating to due process from the U.S. Supreme Court and the Florida Supreme Court have recognized that general jurisdiction, first of all, the sort of paradigm of the exercise of general jurisdiction over an individual is the place where they reside and not somewhere that they travel to in a corporate capacity as part of their job.
But does that go to the long arm analysis or the due process analysis? Should we consider that in deciding whether subsection 2 applies, or should we consider that? Because if it's due process, that's second step. I'm just on long arm subsection 2 right now.
I think that, to be honest, a lot of the courts that have talked about general jurisdiction have considered that component sort of in a mixed way, both in thinking about the application of subsection 2 and what does applying general jurisdiction to an individual mean. And then I think that some of the cases speak to that analysis on step 2 in the due process as well. Sometimes it sort of gets collapsed into itself in all candor. Now, I do think, again, there are plenty of cases that recognize an individual sued in their individual capacity should not be subject to general jurisdiction anywhere that they may work. So some of the cases cited in our briefs that sort of go to this point: Olson versus Robbie, Carter versus the state of Rambo, Wiggins versus Tigret, 4th, 5th, and 2nd DCA cases. Additionally, the other cases that go to this point are from the U.S. Supreme Court are Daimler AG versus Bauman, 571 U.S. 117. That's a 2014 case. And Goodyear Dunlop Tire Operations versus Brown, which is 564 U.S. 915. That's a 2011 case.
Counsel, in any of those cases that you're reciting or any that you're about to recite, do any of them involve an allegation that the defendant who's being hailed into court is not acting in his own interest, or is acting in his own interest and not on behalf, not as an agent of the company, which is in here suing him derivatively?
Well, Olson, Carter, and Wiggins, Judge Nardella, all are cases involving a corporate officer who is alleged to have engaged in an intentional wrongdoing. And there is an attempt to argue that general jurisdiction should apply over them.
What's the intentional wrongdoing against the company itself that was alleged?
Right, is the allegation that they're trying to devalue the company that they work for?
I believe in each of these, the allegation is really just that the officer and or the company engaged in intentional wrongdoing. And can the officer in their individual capacity be sued under general jurisdiction in Florida? Now, one thing to think about is, as far as I know, there's no case, no DCA, no US Supreme Court case or Florida Supreme Court case that has recognized that simply because someone is alleged to have engaged in intentional misconduct as a corporate officer, that general jurisdiction can apply when an affidavit that has not been refuted is presented refuting the
Is
allegation.
it meaningful that this is a corporate derivative action? In other words, the corporate shield doctrine that your client is trying to invoke is a result of being shielded against the very company he's alleged to have wronged. In other words, you're saying that the corporate shield doctrine stops a Florida company from suing its own CEO from, defrauding or otherwise, engaging in malfeasance against the company, right? Isn't that different than, say, a third party because in this case, the plaintiff itself, or, in derivative action, at least, hypothetically, is the corporate shield, right? So is the plaintiff itself blocking its own action against its own CEO? It's a kind of unique situation, isn't it?
I share that quandary too.
Yeah, it may be a little bit of a unique situation, but I think what we need to do is take a step back and think about the circular nature of the allegations that the legal argument that the appellee is making here. The appellee is asserting, I have alleged that a corporate officer engaged in intentional misconduct, and therefore the corporate shield doctrine doesn't apply, and therefore they weren't acting as a corporate officer, and therefore I can sue them in Florida. But we still have the two-step process of the Venetian salami framework that applies and is binding on this court, which is if, as we did here, Mr. Lipsey presents unrefuted declaration that he did not engage in an intentional tort in Florida or direct intentional misconduct at Mr. Francis, they have the obligation to come back and refute that. And there are several cases, including a recent case from this court, Harrison versus NC3 Systems, Inc.
Well, that's why I was on that panel, and I
Yeah.
get that kind of gets into the factual dispute. Well, at least I'll have questions about that too. But I'm still on the legal issue, not whether the allegations are disputed. But here it's a little bit different to have a Florida company not able to sue its own CEO on the ground that when the CEO defrauded the company, it was acting on behalf of the company itself that he defrauded instead of on his own behalf. Can you act on behalf of a company when you defraud a company? Again, we'll get into the factual dispute if I know your client says you didn't, right? All right, that says he didn't. But on the legal issue, can you be acting on behalf of a company when you defraud that company?
Judge Mize, I think the case law is clear that no, that is why there's the exception. But that's where this court in the Harrison case that you were on the panel said, if you can present evidence you were not engaging in an intentional tort, then the corporate shield doctrine still applies.
Wasn't there a footnote in Harrison where we said that this is a lot more than just saying I didn't commit a tort? There were very specific facts in that affidavit that established that the tort didn't occur. Whereas when I look at your client's affidavit, it's really just I didn't commit a tort. It's actually it's a lot more like the case Harrison was distinguishing. I forget the name of the case, but there was another case where we distinguish and we say this is unlike that other case. In this other case, they just said in the affidavit we didn't commit a tort, and that's a legal conclusion. Whereas in Harrison, the affidavit was specific to the facts and actually disputed the elements of the tort in a factual manner. Your client just says I didn't do a tort.
Judge Mize, honestly, in my reading of the Harrison case, I'll have to go back and look at the footnote. What I took away from a key part of the court's holding in that case was that the affidavit said, I disavow any personal knowledge that a tort was committed in Florida that was directed at the plaintiff, which I think our position would be is more similar to I did not commit a tort in Florida as we have in this case. But if the footnote said that there is that it went through point by point, you were on the panel, not me, but the part that I remember being the most similar to this case was I disavow personal knowledge of any tort being committed.
So let me ask, so your client files the affidavit saying, I'll paraphrase, or maybe I'm not paraphrasing. I didn't commit an intentional tort in Florida. And part of your argument here, if I understand, not this first part, but what you briefed is, and the other side didn't come back with an affidavit to raise the factual dispute. So let me make sure I'm following along with your position. So if Mr. Francis had filed an affidavit saying, yeah, you did. You say you didn't do an intentional tort. Yes, he did do intentional tort. See my complaint. Is your position then defeated or weakened here?
Well, I think there's 2 points, Judge Lambert. One, it would depend on exactly what was put in a actual sworn affidavit with admissible evidence. We've cited plenty of cases that the verified complaint isn't sufficient under Florida law. So it would somewhat depend. But at worst, the court was obligated to hold an evidentiary hearing and resolve any dispute of fact. Put Mr. Lipsey on the stand, put Mr. Haystand on the stand, put anybody else on the stand. It is always first and foremost Mr. Francis's obligation and burden to plead and prove personal jurisdiction, not Mr. Lipsey's burden to overcome.
But if he pleads though, and then your affidavit is simply, well, no, I didn't do that. Does that then obligate Mr. Francis to file an affidavit to refute a general denial?
Yes, particularly here where ultimately the only paragraphs of the amended complaint that actually even alleging a conclusory way that Mr. Lipsey engaged in any intentional conduct with respect to Florida, the paragraphs 6, 7, 8, and 9 of the amended complaint, they're all very general. They say he communicated with someone into Florida to further effectuate the plan to pillage the company. It's hard to have a very specific set of denials to a general conclusory allegation.
Well, actually, I mean, you could say, I did not engage in a scheme to reduce his influence over the company or deprive him of money. I mean, your client literally just, I'll grant you that's not the most specific allegations you can have. But yours was even less specific. It literally just said, I didn't commit a tort, right? That seems to me to be a wholly illegal conclusion that would not place his allegations. And given I'm not saying they were extremely specific, but they were factual in nature. And yours seems to be entirely legal in nature, to not put those, given not super specific facts in contention.
Judge Mize, I think one, we would say there's three sworn statements in the affidavit that was submitted with the motion that go to this. I have not committed any tortious acts within Florida. I have never committed any intentional torts aimed at Parkway or Francis. I did not cause harm to Parkway or Francis. We would say that that is very similar to the statement in the Harrison case.
If you were pleading that as a pleading, would that meet the fact pleading standard? Or would that be subject to dismissal as asserting solely legal conclusions?
I think it would be a close call.
Really?
Yes.
I didn't commit a tort. I'd never committed intentional tort. You think there'd be a close call as to whether it met the fact pleading standard?
I think it would be a close call, Judge Mize, particularly if the contention is that good enough to refute it?
How much more closer to a legal conclusion can it get than I didn't commit an intentional tort? Like what statement would be closer on the spectrum towards a legal conclusion than that? Can you think of one? Because I can't.
I can't think of something more specific, Judge Mize, but again, I would go back to.
No, I'm not asking for something more specific,
Yeah.
because more specific would be closer to a factual conclusion. I'm saying, can you think of anything that's more obviously a legal conclusion? Like, is there any way you could say that statement in a way that's more of a legal conclusion than it already is? Can you think of a way?
I'd have to think about it, Judge
I
Mize.
think that means it's not a close call, counsel.
Well, I think that when you have very conclusory allegations with respect to intentional tort conduct that was aimed into Florida, if the affidavit was insufficient, then the allegations in paragraphs 6 through 9 that are the only allegations that
Well,
speak
hold
to.
on. He engaged in a scheme to deprive me of money in the company. That may be general, but it's a factual statement. An intentional tort did or did not occur is purely a legal conclusion that has to be based on some facts. So with his, it seems to be a matter of was it specific enough? And I take that point. But however specific or general it is, if it's factual In order to place it in contention or dispute it, you have to give facts on the other side, not a legal conclusion. I think the law is clear on that. It's got to be facts, not a mere legal conclusion. And what you said, or what your client said, I didn't commit a tort, seems to me to be really obviously just a legal conclusion. And I just asked you, you said it was a close call. You think it might actually be a factual statement. I said, is there any way to make it more obvious? Because if it's a close call, presumably you could state it in a way that's more obviously the other way, a legal conclusion. You couldn't. That tells me it's not a close call and it was obviously a legal conclusion. Why? If I'm wrong about that, shouldn't you be able to tell me a way that is more obviously a legal conclusion than it's already stated?
Judge Mize, the only thing that I can say is if that is a legal conclusion, that is insufficient. Our contention would also be that the only allegations in the complaint that allege any intentional conduct directed into Florida, which are paragraphs 6 through 9, must also be insufficient. And therefore, on the step one of did they meet their initial pleading burden of pleading an intentional tort directed into the state of Florida is also insufficient.
And counsel, that makes sense that they would be married because if they gave more facts, for instance, this happened at 12:01 on September, you could say at 12:01 on September, I was here.
Correct.
When they give you the allegation is that the only thing you can do is repeat it back in the negative. Is that your position?
Yes. And, particularly, I think something else that's important to keep in mind here. So a verified complaint that's not actually verified, that's essentially upon information and belief. Emails and text messages were sent into Florida to further this tortious scheme. After Mr. Lipsey filed his complaint or filed his motion to dismiss in his affidavit, Mr. Francis did not even attempt to take any jurisdictional discovery. Not a single request for documents, not a single deposition, nothing occurred, nothing. So upon information and belief, an email was sent into Florida that was tortious, and then no effort is made to even corroborate it upon information.
But does he need to though? I mean, if your affidavit is not sufficient to raise it, does he need to do anything further? I mean, let's step it back. So let's just say he filed a complaint, not on information or belief. He just filed a complaint that tracks the long arm statute. And if you don't file an affidavit in response, then he doesn't need to do anything, does he?
If we don't file an affidavit
Right.
in response, no, he doesn't need. to
Okay,
present
so
that.
then all right, so past that. So if you file an affidavit that doesn't really raise any dispute, kind of like what Judge Mize is saying, that you allege that I didn't commit an intentional tort, which seems to be a legal conclusion. I mean, if he filed a complaint saying, I allege you have breached a fiduciary duty, have a nice day, that would be a legal conclusion. He adds facts to his complaint, maybe not as specific, but he does allege some facts that you're refuting with a legal conclusion. So whether his verified complaint is truly verified or there's no affidavit seems to be an academic discussion, for lack of a better term.
Judge,
It'd be something to talk with law students about, but as we're sitting here right now, I'm questioning whether the gauntlet has been thrown back to them to have to do anything from a jurisdictional discovery standpoint.
Judge Lambert, I think I would go back to my earlier point, which is if the affidavit is insufficient, it is because the allegations are
But
conclusive.
counsel, but that misses Judge Lambert's point. When you're first pleading as the plaintiff, you're entitled to be conclusory. You literally don't have to give facts. The Venetian salami test says you can literally just state the language of the statute without facts. The only time they have to give facts is if the defendant submits an affidavit with facts, putting it in contention. So if you don't submit an affidavit with facts, putting it in contention, we're still at step one, which is that the plaintiff was entitled to use just legal conclusions. You're kind of assuming you have the same obligation, but you don't. The plaintiff can use just legal conclusions unless you submit a counter affidavit with facts, which I think we're all suggesting to you didn't happen.
Judge Mize, again, I think what our position would be is if you have a general statement, you directed tortious communications into Florida saying we did not commit a tort in Florida, we did not direct a tort into Florida, is refuting a general allegation sufficiently. And other cases have found that sort of more general statement is sufficient. And again, we would say that based on the key part of the holding, I think, in the Harrison case, where the court said that saying I disavow knowledge of a tort being committed would be pretty analogous and similar to what happened here, so it would be sufficient.
Counsel, if we were to disagree with your position on the corporate shield doctrine, where does that leave us for general jurisdiction? What's your best argument that there's no general jurisdiction if all of these contacts count against your client?
That under the due process clause, the state of Florida absolutely should not exercise general jurisdiction over a corporate officer solely because of any sort of wrongdoing. The logical extension of what that would be for general jurisdiction is that Mr. Lipsey, if he engaged in, let's say he got in a fight with someone in California over a breach of contract, that person in California could sue Mr. Lipsey, a Colorado resident in Florida, for something that happened in California because of the general jurisdiction statute applying to any conduct, any act arising out of his
Yeah,
contacts with the state.
but the corporation's a Florida corporation. I mean, in your scenario, Mr. Lipsey, the Colorado resident, is having a dispute with a California resident. That's still a little less attenuated than here. I mean, you're talking about, this is a Florida headquartered company with a Florida officer who's the plaintiff, who's saying that there's all kinds of things here that's being done to the Florida corporation to devalue the Florida corporation. So I'm bringing suit on behalf of the Florida corporation derivatively to address this malfeasance or intentional fiduciary breach by the CEO.
Yeah.
It
Judge
logically it would seem like Florida's the best place for that debate, wouldn't it?
Well, so Judge Lambert, I can understand your point of view on that, but in speaking about general jurisdiction and the concept of general jurisdiction more broadly, and what this rule of law would mean in general for the general jurisdiction jurisprudence in the state of Florida, it would mean that Mr. Lipsey could be sued in Florida for anything.
Why would it mean that, counsel?
Yeah.
Because if you assume Judge Nardell's question, we disagree with you on the general jurisdiction long arm statute, right? We don't think it incorporates corporate shield doctrine, so they pass long arm. And we get to due process. Due process is, are the facts such that the person reasonably could have anticipated being hailed into court in Florida, over this issue. And a person who takes a job as CEO of a Florida company probably would reasonably be expected to be held accountable in Florida for defrauding that company. Whereas getting into a fight with somebody completely outside the company doesn't seem to me to give the same reasonable expectation of being held into court in Florida. I mean, if we were to make that rule of law that a Florida company can sue its own Florida CEO, that does not violate, can sue its own CEO, that does not violate due process, why would that rule automatically extend to third parties outside the company?
Judge Mize, because the general jurisdiction statute is about being able to sue a non-resident or anyone, I should say, for conduct that has nothing to do with their contact. It's a general so.
Yeah, correct. But then there's the due process analysis, right? So you said it was due process issue. So the premise of Judge Nardell's question was, we disagree with you on general jurisdiction. We do, at least under that statute, we don't think there's a textual basis to hold the corporate shield doctrine. And your answer was to her, well, then you'd get the due process, which is the second steps, right? So even if the long arm is satisfied, that doesn't mean that a person can be held into court in the state. You still have to pass the due process prong. And what I'm saying is it seemed to me a meaningful due process difference between a person taking a job as CEO of a Florida company, being held into court in Florida for intentional misconduct against that company, and being held into court in Florida for conduct wholly not involving the company at all by a third party.
Counsel, do you want to answer now or reserve the rest of your time?
I think it'll be easier to just answer
Perfect.
it now. So I think some of the logical extension of that, Judge Mize, is contrary to the language in the statute, which says a defendant who's engaged in substantial and not isolated activity within the state, is subject to the jurisdiction of the courts of this state, whether or not the claim arises from that activity. And so
I'm talking about after the long arm. So you're giving me the language of the long arm. And I'm saying, I agree with you on the language of the long arm. Yes, like you'd be subject to subsection 2. But assuming the long arm is satisfied, you still have to satisfy due process concerns, right? So I'm talking outside the statute. Is there not a due process difference for somebody being held in the court in Florida and their job as a CEO of a Florida company for defrauding that company and being sued by a random third party?
Yes, absolutely. But I think that goes to those types of allegations and conduct should be something that they should be required to meet under the specific jurisdiction prong and not under the general jurisdiction prong, not only based on the statute, but also based on US Supreme Court precedent, recognizing that general jurisdiction applies to individuals in the state where they reside and not somewhere where they have contacts because of their corporate role. I'll reserve the remainder of my time.
Good afternoon, and may it please the court. I'm John Boudet, on behalf of the appellee. I think I might begin with that final issue that was discussed concerning what happens in the scenario painted by counsel of somebody from Colorado being sued by somebody over a fight in California. And Judge Mize, you're correct to point out that the general jurisdiction question has two parts. One has the long arm part, which is answered fully, and the corporate shield doctrine clearly does not apply. And then the second part is due process. And I'm reminded of the old phrase, traditional notions of justice and fair play, right? That's the limit set under international shoe, maybe. And that's what protects any notion of this ruling resulting in some draconian outcome.
Counsel, I think there is law, and I think this might have been what your opposing counsel was referring to. Basically, say general jurisdiction kind of incorporates a due process analysis. So you can't interpret general jurisdiction in a way that would violate due process. Is that a hard and fast rule? I mean, does it make or in a situation is somewhat unique in that, you know, a person's being sued by the Florida corporation that employs them, but they don't themselves live in Florida. Are we able to interpret the general jurisdiction section of the long arm statute in one way? Because it does say that means you get jurisdiction for everything, just not connected to the company. But then interpret in a way that really must not incorporate the full due process analysis, because we still wouldn't give jurisdiction for things wholly unconnected to the company. Does that kind of go against the law saying that general jurisdiction incorporates the due process analysis?
Well, I think that the notion that general jurisdiction incorporates due process means that it is bound by the limits of due process. A state might write a long arm statute that greatly exceeds the limits of due process. That state can write it however they want. It's going to be delimited by the due process analysis. And so I think this court can say that in this instance, you decide the case before you.
But isn't the law say, I agree that states can, you could have some specific jurisdiction that violates due process. Isn't there a lot of case law that says general jurisdiction, the idea that you're going to be subject to jurisdiction in a state for anything, for any causes of action, because your contacts with the state are so extensive? Isn't there case law saying that actually is coextensive with due process?
There may be some cases. I don't know that it necessarily means that phrase could perhaps be manipulated in a way that isn't applicable here. I was simply making the point that if this fictitious hypothetical California versus Colorado matter arose in a Florida court, that the defendant in that case would have a viable due process argument, even if 2 years earlier that defendant had been found to be subject to personal jurisdiction, general personal jurisdiction arising out of his activities in serving as president of a Florida company. I think it's a completely different due process analysis and may result in a different outcome. That's all I can say on that issue.
Counsel, what should we make of the forum selection clause? And do we actually know what it says? I saw it referenced. Is that an important part of your argument that?
It is not part of our argument. I don't believe that we grounded our jurisdictional arguments on that in the individual, I don't know whether in the individual case, obviously, to the extent that parties contractually agreed.
I was noting you guys did rely somewhat on the Hatfield decision that Judge Gerber wrote, and Judge Gerber did seem to rely somewhat on the forum selection clause there. And I know there is one here, but I don't know much about it. So
I will
not
confess to
important.
not having focused on that issue at all, Your Honor. That is not one of the issues that
No
was
problem,
argued.
counsel.
Yeah. But I will talk a bit about this, the burden shifting, because I think that's really such a critical part of this case. There has been an attempt to portray this complaint as this kind of superficial, you said the defendant committed a tort and didn't do much else, and counsel cited to just 3 paragraphs. That is not what this complaint does. This complaint has extensive details, talks about specifically increasing the compensation of Mr. Lipsey, increasing his own compensation to exceed market levels, decreasing the bonus pool to deprive Mr. Francis of the benefits of the operating agreement. There are very specific allegations, and there's specific allegations that his phone calls into Florida, communications with Mr. Heastan were done for the purpose of furthering the scheme.
Counsel, do you concede that the verification of your complaint was qualified and therefore defective?
To the extent that, yes, I could see that a verification that says upon information and belief, if we had been required to file an affidavit, would be insufficient. I can see
Correct.
that.
So your argument relies on the idea that their affidavit must be insufficient to counter your complaint.
It is.
Anywhere where their affidavit was sufficient, I'm not saying it's sufficient everywhere, but anywhere we find it to be sufficient, we have to assume their things are true because you failed to submit any sworn proof, right?
That's correct. The case law talks about an affidavit fully rebutting the allegations of a complaint. That's key, because here there was no attempt to rebut
Right,
any
but
of
if
the
they rebut
allegations.
one part of it, we have to take that part as rebutted, correct?
Yes. For example, if we had pled that Mr. Lipsey was a resident of Florida, and he files an affidavit that says, no, I'm not, I'm a resident of Colorado. If I don't counter that with evidence that he's living in Florida, he wins on that issue. But if he says, I'm not a resident of Colorado, and that's all his affidavit says, and he doesn't rebut all the other allegations, we don't need to rebut others. That's where we are. I think that's what Judge Jordan.
Counsel, when we look at contacts, do we put them in the context of the defendant we're evaluating? And I think there was some opposing counsel did this somewhat, and they looked at Mr. Lipsey and they said, listen, he traveled 100 times this last year. Let's use that hypothetical. And
Right.
only, 10% of the time was it in Florida. Do we look at it like that, or do we look at whether that 10 times in itself was enough? And what would give us guidance on how we contextualize contacts?
I had never heard that argument before.
And maybe they didn't
It's
make
here.
it, but there was a reference to.
No, I mean, I had never heard it before it was made here, that we should look to see what their overall travel plans are. He has 100 businesses, only one of the businesses is in Florida. That doesn't matter. If you're doing business in Florida, then you're doing business in Florida. The fact that you're doing business in 40 other states doesn't matter. So I don't think that is a persuasive or a proper analytical framework for determining personal jurisdiction. He clearly has more than minimal contacts in this state, serving as the CEO of a Florida-based company. Nothing in the affidavit refuted the allegations that Parkway is based in Florida, that its employees are all in Florida. Those,
Not all its employees were in Florida.
well, Mr.
CEO was
Lipsey was not, correct. All the headquarters were here, the HR department was here, all the other arms of the company are here. But correct, Mr. Lipsey was in Colorado. I think that the case that may be the most analogous to our situation, there's a case called Pianezza, which really talks about this notion of an intentional tort by a corporate officer directed, done for their personal benefit. I think that's a clear part of this. This is not like the cases where a corporate officer is accused of an intentional tort that benefits the corporation. There's a Hyatt case or something, a hotel case that where an executive, got found to have personal jurisdiction because they had added a charge to the hotel bill. But that was for the benefit of the company. Here, the allegation is that Mr. Lipsey engaged in this conduct for his personal benefit.
What should defendants like Mr. Lipsey do if they're put in a situation where to every complaint, there is an allegation just added that they acted for their own benefit? Do we by not reversing this decision, create that as an outcome for future defendants in Florida? That if they are living in another state, they could be hauled into the state of Florida just because an allegation is added to a complaint, as simple as they were not acting on behalf of benefiting their corporation, they were acting in their own interest. How do we prevent that outcome?
I think.
Or is that a fear we should have? Why not?
I mean, I think it's a fair concern. I think that a plaintiff, first, we have sort of, 57-105 standards for requiring some good faith investigation to support the allegation.
What if it's also true? Like, what if somebody was just acting on their own benefit, but they were using their corporate powers to do so, but their subjective intent was, I think this is going to be good for me. If it is any person who takes a job for a Florida company that takes some action that benefits themselves now subject to jurisdiction here?
I think good for themselves to the detriment of the company, and that constitutes a tort. Those are the things that we're talking about. Not,
How do we draw that
I got a
line?
promotion and it's going to be good for me to become president of.
So as a jurisprudential matter, how do we say that in an opinion, right? So yes, acting on your own as the CEO of a Florida company doesn't give jurisdiction. But if there's an allegation that it harmed the company in the meantime, in the course of doing it, that does give jurisdiction?
I think where there are unrebutted and legally sufficient and detailed allegations of self-dealing that have been rebutted only by a conclusory allegation or a conclusory sentence, I didn't commit a tort, that would be sufficient to.
All right. So what if a third party sues the CEO of the company and says, hey, the CEO of the company had the company enter into a contract with a third party that caused an intentional interference with me, or it violated my non-solicitation agreement or something, right? And so he's taken an act on behalf of the corporation, but he did it because his brother's the CEO, or he's got shares in the other company. So it's clearly a corporate act, clearly done on behalf of the corporation, right? But there was some personal interest involved. Does that mean there's jurisdiction for that? Can the third party now sue him personally in Florida?
I think depending on the details, there may be situations where that could be. If the president of a company in Kentucky, for the purpose of enriching his brother-in-law's company, causes harm to a Florida company through the improper exercise of corporate authority that incidentally benefits his Kentucky company, but what he's really doing is enriching his brother-in-law. I don't have a lot of angst about the state of Florida asserting jurisdiction in that
Is that
situation.
just because he's a bad guy and he deserves it though? Like, what's the, give me the legal analysis on asserting jurisdiction over
I
him.
think the legal analysis would be that the actions were taken were tortious, right? Tortious interference. That's an intentional tort by a corporate officer done for a personal benefit with the expectation that would harm or cause harm in Florida. I think that.
So how does that deal with the corporate shield doctrine? Are we just getting rid of it?
Well, the corporate shield doctrine does not apply to intentional torts done for personal benefit. That's the answer to that. So I think that it would be, again, there may be some close calls, but if I can come up with a full hypothetical, I can probably come up with one that would land jurisdiction in Florida. But here we have a different case. We have a president of a Florida company accused of personal misconduct to the detriment of the company with detailed allegations and a superficial and conclusory affidavit in opposition. Respectfully, we think that the trial court should be affirmed unless the court has other questions. I'm happy.
Can I ask you what I thought about was a really strong point in your opponent's briefing? Was it the idea of personally operating a business in Florida? Okay, and you know, that's I think it's subsection 1A says that if you personally operate a business in Florida, you're subject to specific jurisdiction here. And I can't imagine how the CEO of a company is personally operating that business. I mean, he's clearly operating it as the CEO, but he's not personally operating it because he's doing it on behalf of the shareholders. And I know you say he did improper things that were for his personal interest. And I think you say that those go to committing a tort in Florida as well. And that's kind of your backup argument, which is, and I think we can address that on a tipsy coachman basis, is that those constitute committing a tort. But he still did those things as CEO. And none of those things to me, none of the bad acts that you describe, even if they might be committing a tort, none of them seem to constitute operating a business personally. So I don't see any business he operated other than Parkway, and I don't in his capacity as its CEO. So what exactly is the, and if you want to just say we think the trial court got that one wrong, that it should have been committed tort, that's fine. But if you're saying that's one of the bases on which we should affirm, what was the business he personally operated in Florida? Just doing torts in Florida and doing illegal things, not operating a business.
No, I think that you know, if we're talking about a tort of negligence, it's a different thing. But when we're talking about intentionally defrauding a company for the purpose of enriching
That's a
himself
tort.
personally.
So I asked you a specific question.
Yes.
What's the business he operated personally?
I
Because
suppose the business would be the business of enriching Mr. Lipsy to the detriment of.
okay,
the
so you're just
corporation.
saying doing a bad act is operating a business. Does that strike you as a good argument?
I think that doing a bad act is not sufficient.
Okay,
of
so
course.
give me the, so I asked.
But I think that this was the operation of a business in the sense that he took the business of Parkway and converted it to his own benefit. That's the allegation. And that he enriched himself as a result. Does that constitute operating a business? It's not an issue that came up, Your Honor. I understand your point.
Well, that was one of the trial court's findings. That was the trial court's hook for jurisdiction, and the trial court didn't address committing a tort.
Specific jurisdiction was based on that, and
Yeah, it seems to me to be wrong.
I think that the only argument I have on that point is that operating, engaging in this scheme for the purpose of enriching himself and doing so through the vehicle of Parkway and his position as CEO could constitute operating a business. That's the best I've got.
So trying to deprive the plaintiff of money as CEO constitutes operating a business. That's what we got.
That's all I got.
Okay.
It's okay to say, you know,
Yeah.
under 1A1, that's probably not right, but
Yeah.
I ought to win on.
I think that's where I got.
Say that.
It is. I think you're right, Your Honor. I think that we have a much better argument on
On the other stuff.
the other issues. And so I don't need to rest on that.
All right, counsel.
Thank
We
you.
have no further questions.
Just make, I think I didn't get to it initially, just the main point that I wanted to focus on is relating to specific jurisdiction and committing a tort within the state. And our contention that this court is empowered now that the Amendment 4 case was issued in 2020 and supremacy of the text principle is formally the jurisprudence of the state of Florida to reconsider whether, or consider for the first time, whether committing a tortious act within the state requires physical presence in the state. And as of this morning, before we walked in to the courtroom today, there's been no case from the Florida Supreme Court answering that question since Amendment 4. And the main point I wanted to make in construing the committing a tort in the state provision of the statute and why that means physically present in the state is to compare it with 48.193(1)(a)(6), which is the provision that talks about, quote, causing injury to persons or property within the state arising out of an act or omission by the defendant outside of the state.
It's a good argument. I mean, you're basically saying when they talk about out-of-state acts, there's a provision on that. And
Yeah,
it gives two instances where out-of-state acts give jurisdiction, and communicating into the state's not one of them. Are you basically saying the Amendment 4 case overruled Wint?
yes, basically,
Okay,
Judge.
so you think
Morris.
no, I just want to
Yes.
know, you think we're not bound by Wint anymore?
Correct. I think the court is not bound by Went and is empowered to consider, because there's no longer any binding precedent that, based on the supremacy of the text principle, committing a tort in the state requires physical presence in the state.
And you're gonna talk, I have one more question, if that's okay. I took your point about general jurisdiction kind of being for where your residence is, and it's kind of a unique case, and kind of his personal residence was in Colorado, and it's kind of he took a full-time job and located in Florida. Kind of his business residence was in Florida. And so I guess my question is, what level of presence, would be required before you would say you're wrong about that? So say it's, much bigger company, right? Say he's getting paid $100 million a year and they've got him a private plane. So he's literally commuting into Florida every day, right? Maybe he lives in Charlotte or Atlanta and he flies in every morning on a private jet. He's here 9 to 6 every single day. Is it still there can't be general jurisdiction because he's not a Florida resident?
So I actually think that would be a closer question, and here's why. There's other Supreme Court cases talking about, in the context of a corporation, where is a corporation subject to general jurisdiction? And we normally think of that as principal place of business, or where you're incorporated, depending on the type of corporate form, right? The case will come to me, or I can file a supplement to the court. But there is an old Supreme Court case that we often cite when we're talking about this in the corporate context, where a company that temporarily relocated all of its operations to Ohio during World War II was subject to general jurisdiction in there,
But-
because that was effectively where it was home. So
But in my hypothetical, there's not been a temporary relocation, right? This person lives in Charlotte or Denver or Atlanta and just comes in every day,
Yep.
right? Is a resident of there, or maybe maybe it's a regular person just drives across the border, right? The company's in, right on the border of Georgia and Florida, and they live in Georgia and they come into Florida every day. You acknowledge it, even if the person was clearly and obviously a non-Florida resident, they're a resident of some other state. There is an amount of time they could spend here, an amount of work they could do here, even if it's solely for their work, right? The person who comes here 9 to 6 every day is just doing it for work. They would be subject to general jurisdiction if they're here enough, spending enough time here, right?
I think that it would be possible depending on the factual circumstance. And again, the only analogy that I know of is when a corporation sort of temporarily relocates somewhere else. So the closest analogy that I could think of would really be more a person who is a resident of Georgia, but Monday to Friday lives in a condo in downtown Jacksonville and goes back home every weekend. I think that would be the kind of circumstance where you would certainly have at least a very close call on whether they should be subject to general jurisdiction in both places.
So really, it's not that he was not a Florida resident. It's just a matter of, did your client spend enough time here?
Such that they should be considered to be at home in the Florida
Yeah.
state.
Yeah.
Yeah. Yes.
Thank you, counsel.
you.
I want to thank you both. This was well argued and well briefed, and we will be in recess.
Thank you.
Oh, yeah.
I missed that you were a Gunster